Why is that not recording? Kangaroo court, noun. A collection of uneducated wannabe vigilantes braying at each other, usually in a pub or similar location, deciding upon the guilt of people they don't know, people who they're likely not ever going to meet, with vastly different lives and internal narratives than those so-called kangaroos could ever really understand, ignoring all recognised standards of law and ideals of justice. That was, of course, a joke. Not really, but kind of. I feel like if Webster could fit a whole explanation for these concept topics in a 3-line definition, then what the fuck did I spend all that money on my degree for? Yes, I'm broke and bitter. You're watching a YouTube video essay, what did you expect? If you've been on social media at any time in the last few years, then you've no doubt seen a plethora of edits and remixes of any number of high-profile court cases in real time. While cameras have been in courts since the 1910s, with the rise of social media, this footage has seen widespread attention in a way that the justice system simply could not have predicted back then. So for starters, what is the justification for having cameras in courtrooms? Surely, considering the very personal information that is divulged in court proceedings and our Western society's general ideas of individuals and their rights, courtroom proceedings should be, if not completely private, at least not available for widespread public consumption, right? Right? Well, it's complicated. Yes, once again, if you are not comfortable with ambiguity, then the law is not for you. Not that any of you, I think, are actually want to be lawyers, because you're all smarter than that. You're all much smarter than that. Questions around the efficacy and merits of cameras in courtrooms have been around since their introduction, only to become more contentious with the advent of the television and, again, with the introduction of the internet. Social media is just another progression in this conversation that's been going on now for over a century. Despite over 100 years of discourse, though, much like the operation of our justice system, this topic is not in any meaningful way settled. Judicial proceedings are generally an open public affair across the Western legal tradition. In Australia, under the principle of publicity, which has been imported from the United Kingdom, in order for justice to occur, it has to be seen to be being done. In the US, the Sixth Amendment guarantees criminal defendants the right to a public trial. This has been clarified by the Supreme Court in the US in several different occasions, specifically Richmond newspapers and Virginia, which was a 1980 case, in which the Supreme Court highlighted both the First and 14th Amendments, which guaranteed the right of the press and the public to attend trials and gather information. But it's a long way from simply being able to attend trials to seeing the proceedings splashed all over TikTok and whatever it is that Twitter's called these days. There are cases in which a court will be closed, for example, if the public overly disrupts the proceedings, in instances where a defendant may have multiple cases and the outcome of one may affect the proceedings in another, or when certain testimony, for example, really sensitive matters involving children. But these are the exception rather than the rule. In Australia, you can walk into your local courthouse and sit in the back very quietly and respectfully and watch the police body camera footage of the drug bust on the little old man's apartment up the road, and no one will even look at you sideways. And of course you would want to do that. His setup was fucking epic. Still impressed by that all these years later. That being said, the distinction around what counts as public varies widely. In the UK, the pushback against publicising of images of what went on in courtrooms began in 1906 when Sir Gorrell Barnes, the then president of the divorce court, sought to save the embarrassment of those who might find themselves engaged in divorce proceedings. He prohibited sketch artists from taking the likenesses of witnesses in such matters or from those who were entering or leaving the court. However, some 20 years later, when the matter came up for discussion in the House of Lords, the Lord Chancellor raised some of the concerns surrounding the prohibition of cameras in courts that we are still talking about down to this day. To quote, "Your Lordships will not forget this, that for some purposes publicity is necessary for justice. When a man or woman has been publicly accused and the matter comes into court then, if the judgment of the law is in his favour, it is right that fact should be brought to the public knowledge. On the other hand, there are cases where if a verdict is against him, it is equally just that he should suffer the penalty of publicity. Therefore, one must take care not to endeavour to suppress publication of facts of that kind where the very publication is essential to justice being done." and not to create suspicion in the public mind that because there is secrecy, there is some defect in the administration. Despite the Lord Chancellor's caution, the bill passed, and it wasn't until 2005 that changes were made to allow cameras in some courts in some cases in the UK. Similar concerns have been made in Australia, where matters relating even tangentially to national security can be so secretive that defendants' own lawyers may not be privy to some of the evidence brought against their clients. Yeah, this is an ongoing conversation. In 2012, a provision was written into the Crime and Courts Bill, allowing the Lord Chancellor, in conjunction with the Lord Chief Justice, to make changes to several pieces of legislation that prevented broadcast of proceedings and their outcomes. The changes have seen hearings in London's Court of Appeal and the UK Supreme Court televised, though filming is limited to judges' sentencing remarks. A pilot program filming sentencing decisions in criminal trials in England and Wales was undertaken in 2016, showing that despite a wide range of approaches to cameras in courtrooms across jurisdictions, the general move is towards more open transmission of courtroom proceedings. Even these changes have been too much for some, with concerns being raised over the possibility that the presence of cameras could lead to those who find themselves in court playing to the cameras, and that the carriage of justice may be affected as a result. Comparisons have also been made between cameras in courtrooms and police body camera footage, which, while ostensibly was introduced to increase police accountability, has many concerns over who has control over the footage and how it can be used by actors with less than altruistic motives. Despite these misgivings, arguments for limiting cameras in courtrooms have generally been seen to be more about judges and lawyers maintaining control of the proceedings, with words like dignity and decorum being thrown around a lot. Though with the rise of social media, there has been an increase in concern and even suggestions that there is some merit to the arguments that cameras could have an intimidating effect on judges, witnesses, and juries. The juries one is something to put a pin in. We're going to come back to that. Another concern is certainly one that's more substantive, that particularly in high-profile court cases, the dispute resolution power of the court would be weakened if the public were invited to see the whole trial for itself. The public wouldn't necessarily be as willing to accept the jury verdict as the final word on the case, having seen the testimony and evidence for themselves. People do tend to form their own opinions and weigh in on these things regardless. We see it all over social media whenever there is a high-profile proceedings. But with some mystery surrounding court proceedings, it's still less likely to have as much weight as it would in a case where all of the facts were known to anyone who wanted to partake and pay attention. This could perpetuate division of the public over the issue rather than bring about finality, which is what jury verdicts are intended to do, be the final word on a case. This, in part, is what was so disturbing about the O.J. Simpson trial. Over 100 million people tuned in to watch the infamous verdict, and many commentators have asserted their belief that the sensationalised nature of the trial contributed to that verdict. Questions surrounding it still exist to this day, and many blame the pervasiveness of television cameras in that case for the continuing conversation around that trial. The O.J. Simpson trial was certainly not the first time the judicial system had to deal with this sort of widespread public interest in a criminal procedure. The Supreme Court was first confronted with the issue of whether cameras could be admitted into the courtroom without conflicting with ideas around due process during the 1962 criminal trial of Billy Solestes, an infamous Texas con artist. The trial had in attendance, along with the usual courtroom trial actors, 12 television cameramen, 3 separate microphones, dozens of different cords and cables snaking across the courtroom floor, and a partridge in a pear tree. In Estes and Texas, the court held that the presence of the cameras at that trial had impermissibly interfered with the defendant's right to due process, and as a result, his conviction was overturned. In a 1965 United States Supreme Court decision, Chief Justice Warren wrote that the television camera, like other technological innovations, is not entitled to pervade the lives of everyone in disregard of constitutionally protected rights. Justice Harlan concurred to note, however, that The day may come when television will have become so commonplace an affair in the daily life of the average person as to dissipate all reasonable likelihood that its use in courtrooms may disparage the judicial process. And that same argument could certainly be used today when talking about social media and the internet age. 17 years later, in Chandler and Florida, the court ruled the presence of cameras on their own could not automatically be considered a violation of due process, and that television media should be treated like its print counterpart. That being that the right of media to attend courtroom proceedings was protected under the Constitution. For nearly 20 years now, every state in the US has allowed cameras in the courtroom at the appellate level, according to each individual judge's discretion. Some states allowing cameras at other levels of the judiciary, though the Supreme Court has pushed back against having cameras in the highest court of the land. And federal courts likewise have been prevented from broadcasting from their courts, even in cases where the judges themselves are seeking to allow it. Higher ranking judges have even reprimanded and put pressure on federal trial judges to prevent such a thing in several instances. There are some exceptions, for example, in New York, where there is a local rule that allows individual judges to make the call for cameras in their courtrooms, and this is both in the southern and eastern districts. In some cases, this has meant that cameras have been allowed in the court proceedings, even over the objections of the parties involved. The purpose of this, as stated by either the judicial or legislative branch of each state, is to serve one of the founding pillars of our justice system, that justice is seen to be being done. And this brings up one of the key considerations that we have to continue asking ourselves with the presence of cameras in courtrooms becoming so commonplace. Do they in any way impede the ability of justice to be done? In a 2007 National Judiciary Conference, judges and lawyers alike espoused the ability of cameras in courtrooms to demystify proceedings for the general public and to increase the public's confidence in the rule of law. Plenty of other benefits have been noted too, including their ability to educate the public, which admittedly gets most of its information at the moment on the operating of the judicial system from Hollywood movies and Dick Wolf, Law and Order, both of which have a vested interest in dramatising what is in essence an administrative process or an academic affair from the perspective of the court, certainly not from the perspective of the individuals involved. But as we've already no doubt seen from this discussion, the individuals involved are only one small part of this conversation, and sadly, very rarely a central part. The desire to remove secrecy from within the judiciary must be balanced with people's right to a fair trial. It's been a topic of much ongoing debate, and the political landscape that provides the backdrop for such discussions has to be acknowledged for the effect that it has had on the public's perception of such matters. But in this discussion, the camera's ability to be an interpreter of events is often overlooked. Courtroom footage is highly mediated. This is in contrast to the unwritten rule that court transmissions are just filming, where the camera is directed, how long it is filming in a particular place, where a camera is pointed, if it's a wide shot or a close-up, how long it might focus on any individual. These are all choices that someone is making. Limiting filming just to judges' sentencing remarks may help protect the efficacy of court proceedings, but they are not in any meaningful way neutral, and the decision to film and broadcast them is also not neutral. The judges' findings will be filtered through their experience, and judges' remarks are often not limited simply to the facts of a case. Having access to these summaries and the general culture of any particular court is a widely valuable tool, so there is no denying that this information is going to be valuable for anyone needing to present to court for any reason, particularly for anyone who might find themselves in a court in front of any particular judge. Having an idea of that judge's personality and the way they run their courtroom is undoubtedly going to make the whole process much easier. Access to a video library of diverse civil proceedings will allow future court participants, whether they are lawyers, litigants, witnesses, or jurors, to better understand and anticipate the way a courtroom operates. I hope this has made it really clear that for literally every argument for or against having cameras in the courtroom, there are 3 arguments for the opposite. Having every court procedure recorded and in some way available for public consumption can desensationalize court proceedings and make it seem more everyday. diverting the public's attention away from the more sensational cases and to the more hodrum, everyday nature of courtroom proceedings is certainly a valuable asset. Though I would certainly argue that it is not necessarily what we see being done, especially not on social media. I'm not blaming social media for everything, by the way. There have been several pilot programs in the US that have shown how valuable this can be. What is concerning for those who are interested in the way that the legal system can be and has been weaponized by certain bad faith actors is through the use of widespread sharing of courtroom proceedings, as was seen in the Depp and Heard civil defamation case. You knew I was going to talk about it, didn't you? You knew I was going to talk about it. Before we go any further, I'm just going to say right now, if you were simply looking at the facts of that case, the jury made a mistake. Let's talk about it, shall we? Controversial. What is certainly concerning for those interested in the way the legal system can be and has been weaponized by bad faith actors is the way it can be further weaponized through the use of widespread sharing of courtroom proceedings, as was certainly seen in the Depp and Heard civil defamation case. Nicole Badera identifies this as a new emerging trend. To quote, "A defamation suit offers a perpetrator a deepening of the power disparities in the relationship and face-to-face contact with a survivor." Badera says, defamation cases are often a punishment for leaving. The idea that perpetrators may weaponize the legal system in order to control their victims is certainly not new and certainly not limited to courtroom footage. It is something that most victims, when leaving a DV situation, have to face. The idea that child services may be called on them to try and cast doubt on their parenting abilities, that the police may be called upon them. There have been cases that have involved perpetrators getting victims hooked on illicit substances in order to discredit them, reporting reactionary abuse in order to discourage victims from seeking aid in the fear that they will not be believed or that they themselves will be framed as the abuser. These are all things that an ex-partner may try to weaponize against a survivor in order to force them to stay in the relationship under the power and control of the perpetrator. It's quite terrifying to think that an entire system can be weaponized against you like that, but just ask any black person. They've been living with it their entire lives. Now, this is certainly not limited to courtroom proceedings. Terms like so-called mutual abuse, which have gained popularity since the Depp and Heard trial. So-called mutual abuse is a term that is not agreed on by experts in any sense of the word. But these tactics of trying to frame victims as also being perpetrators. These are all tactics used by perpetrators to continue the control and abuse of their victims, as they might seek aid from the structures, including legal, to escape the cycle of abuse. These are tactics that are recognised, though sadly not necessarily by magistrates when you go before a court. You will find yourself dealing with the same system that perpetrators will do anything they can to continue their influence or control over their victims, and that can include dragging them through legal proceedings to keep them enmeshed in this cycle of abuse for as long as possible. Before the Depp and Heard trial, there was an assumption that victims talking about their experiences of abuse was a form of protected speech. The Depp-Heard trial has called that assumption into question in a very public way. The way this may impact future defamation cases is also overlooked amongst the means and clipped out of context zingers shared across social media. Interest in this particular trial was also driven from social media, with research showing that it was social media that was sharing interest of the trial first to be picked up on by the mainstream media after the fact. This is something that is worth noting because a lot of the arguments around having cameras in courtrooms has been around protecting the freedom of the press and their right to have access to trial proceedings. And while courtrooms are, again, a public open affair, what public means varies greatly from state to state, place to place. For example, as I mentioned earlier, you can go into a criminal trial in my own backyard and sit in the back quietly and respectfully, but if you were to whip out a camera and start recording, you would be removed from the court. Simple as that. It is public, but that doesn't mean you have the right to publicise it. Even journalists appearing in criminal court cases in Western Australia are not permitted to take sketches while in the courtroom. They have to wait until after they've left to make their artist's impressions. I mean, say what you want, but like the Depp and Heard business would not be going on in Australia. That's all I'm saying. That's all I'm saying. It's interesting to note that another trial involving the two parties in the UK didn't draw nearly as much attention, and this is in part due to the limits around recording of court proceedings in the UK. It is undeniable the effect of streaming this trial had. There are real concerns that in this case, the jury may very well have been swayed by social media and the public's perception of the trial. Even had the jury completely followed the judge's directions not to in any way engage with social media on the matter, it's impossible to believe that their friends and family wouldn't have been talking to them about the case. Without having a jury completely sequestered for the entire 6-week trial, it's impossible to deny that social media had to have an impact on them and their decision. And if you look at the inconsistencies in the verdict, it becomes very clear the effect that this had. To prove defamation in the US, a plaintiff must convince the jury that the statement in question was knowingly false and that its intent was negligent or malicious. That's a very high bar. Legal experts have pointed out that the verdicts seem contradictory. How can it be that Amber Heard was defamed when Johnny Depp's lawyer said that her allegations were a hoax, and yet Johnny Depp was also defamed when she said she was representative of domestic violence? That's inconsistent, and you can't have an inconsistent verdict. And in this case, we do. I may be putting the court before rigorous study and peer review here, but it is undeniable to anyone who was on social media during the trial that as far as public perception went, there was a clear winner well before the jury returned their verdict. And regardless of what the law says should have happened, this played a part in the outworking of justice in this case. The trial may be done and dusted, but the effect that it has had on the legal landscape is still being examined, with it once again bringing back into focus the questions of if cameras in courtrooms have an impact on the ability of our legal system to see justice being done. All the concerns and questions raised with each step along in our technical progress, we've been forced to re-examine what it means for our justice system to be open and transparent, and how far that openness must go in order to meet the standard of being public. But whereas in times gone by, the concerns raised around its propensity to interfere with justice being done were deemed unfounded, in the trial between Depp and Heard, we can clearly see that the opposite can be true. We have to take seriously the possibility that widespread consumption of court proceedings during active trials has the ability to impact the outcomes of said trials and thereby pervert the course of justice. Regardless of where you fall on this, it is clear in any case the questions of cameras in courtrooms is yet to be settled, and the question only gets more complex as our ability to disseminate the images gathered grows. That leaves us with another question. What the fuck even is justice anyway? We're so concerned about seeing justice being done, but what does justice really mean? Well, I've already been talking for I don't know how long, and I'm really, really sweaty, so I'm not going to answer that today. But I am in my next video. So if you want to see that, if you are at all interested in any more discussions that I have on all of this sort of business, looking at the philosophy of our legal system, of, all the other stuff we're talking about, philosophy, criminology, legal theory, all that good stuff, hit the subscribe button, hit the follow button, do all of the things that I'm supposed to ask you to do at the end of a video. And thank you so much for watching.